judge who calls himself a judge sit in court and misconduct himself in such a manner and expect the country to be quiet? Now here is where the matter becomes even more extraordinary. This order, an order with massive political, legal and democratic consequences, was pronounced without the court's full judgments, as I've stated supra. There were no written reasons, no factual findings, no legal analysis, just a naked directive issued into the public domain. And the whole constituency is now being told that there must be a rerun. I am a practicing lawyer of experience at the bar. I understand that courts occasionally deliver rulings with reasons to follow. But such a practice is the exception, not the rule. And it is never an acceptable approach when the stakes are this high, when a parliamentary seat hangs in the balance, when constitutional rights are imperiled, and when the votes of thousands of citizens face annulment. For a judge to casually void an entire constituency elections without first ensuring that a complete reasoned judgment was prepared and published is not merely irregular, it is judicial irresponsibility of the highest order. We have carefully reviewed the relevant authorities, including the Supreme Court's decision in Kojoba and Ghana Water Company Limited and another. And in that landmark case, the court affirmed a long-standing principle, quote, in the interest of substantial justice, a court may, in limited and carefully circumscribed circumstances, grant relief not specifically sought by a party, but only where such a relief is unmistakably supported by the pleadings and evidence, causes no unfairness or surprise, and brings true finality to the issues properly before the court. Let me emphasize, this is a narrow exception, not a judicial blank check. The Supreme Court made abundantly clear that such power is to be exercised only when, 1, the parties have had a full and fair opportunity to address relevant issues, the evidence unequivocally supports the alternative relief, and 3, there is no element of surprise, prejudice, or procedural ambush. Now, ladies and gentlemen, none, absolutely none, of those conditions exist in this case. The High Court order is not a principled application of the Kojoba doctrine or any other known doctrine. It is a brazen abuse of it, like the judge who invoked the animal farm to remand Abronye. Consider the following facts. 1, the petition did not plead irregularities in all 152 polling stations. The petitioner did not lead evidence concerning 152 polling stations. The parties never argued about 152 polling stations. And no one, neither the respondent, nor the Electoral Commission, nor the voters of Kpandai, was put on notice that the entire constituency election was at risk of annihilation. In fact, the key witness to the petitioner underscored the fact that all they needed was a rerun in some 41 polling stations. He again added that the collation was done without due notice to him. Has the judge read the CI? Has the judge listened to the Electoral Commission regarding the violent conduct of the petitioner and his followers, leading to the termination of the collation at Kpandai and eventual transfer of collation to Tamale? Indeed, this is not substantial justice. This is substantial injustice, a textbook case of judicial overreach masquerading as equity. Let me be clear. We do not accept that the petitioner proved his case. But even if he did, the court found credible evidence of wrongdoing. The remedy imposed is still fundamentally flawed. It is whimsical, unlawful,
one thing
and manifestly
that if I'm
unconstitutional.
able to do it today,
Under Section
and
20
the next
of
day I am
PIDC
no
Law
more the MC,
284,
I will walk
the High
out
Court may
with my
void an
head
election
up
only
and my chest
to the
up.
extent
Is
that
the water
proving
crisis in the
non-compliance
Amanteng
affected the result.
municipality? It's a serious
The law
problem
demands
that we are
precision,
facing, and it
not
has been
wholesale
biggest
distraction.
issue that we
And my
have been
Lord
trying to
Atukpo
solve.
was very clear.
We will
In
drill
this case of
mechanized boreholes,
Akufo-Addo
but
and
all
others,
the same, we are not getting the water
where
because
pink
of
sheets
the
were
low
not signed.
water table that we
I
are facing at
remember
Amanteng municipality.
the
One thing that
argument
can solve this
of
problem
learned
is that there's a river
Tachuchi Kata
at
in
that
that
place,
matter,
River Pro.
where he
If
said
you're able to
it would be
connect that water
constitutionally
to
unwise
Atebu
to
Amanteng,
nullify
I know very well that the
the
water
vote
crisis in
merely
Atebu
because
Amanteng will
the
solve.
presiding officers did not
So
sign.